All right, good afternoon, everyone. We're back on the docket. I'm Judge Jackie Powell, and what I'm going to do is I'm going to start with the first appearances. For those of you who were not here this morning, this is first appearance court. What that means is that I'm reviewing the police report and determining whether there is probable cause to detain you and to set release conditions. And then further on in the docket, I have some of you who are coming back for a second or third time, and we'll deal with those as we get to them. Please remember that everything in this courtroom is being recorded, and so anything you say can and will be used against you. You do have the right to remain silent. If there's something you want to let me know, I would advise you to speak with your attorney before speaking on the record. When I call your name, I'm going to ask you to just step up, and I'll address each one of you in order of my docket. So I'm going to start with Chunte McGee, C-H-U-N-T-E, McGee. Do we know where Ms. McGee is?
Good afternoon, Judge. Ms. McGee is here.
Good afternoon, Ms. McGee. Ma'am, you're before the court today on count 1, battery on an officer, 2, resisting officer with violence, and 3 and 4 are probation violations, and count 5 is possession of a forged driver's license. The court does find probable cause as to counts 1 and 2. I will impose a bond of $1,000. Count 5 will be $1,000. 3 and 4 are no bond holds for your felony, Judge. My notes indicate that you should be in court tomorrow at 8:30. So good luck, ma'am.
Judge, our only request is we're going to ask the court to sign a photo order.
I will. Thank you.
Thank you, Judge.
Jared Gibson.
Mr. Gibson is here at Main, Judge. He's approaching. Come on up, sir.
Mr. Gibson, good afternoon. You're before the court today for 2 misdemeanor capias, one of them being a municipal ordinance. The court does find probable cause. What does Mr. Gibson wish to do?
Judge, I spoke Mr. Gibson in reference to count 1, which is the state offense.
Yes.
My understanding is missed court on, I believe, September is when he informed me, but he wishes to resolve that matter today.
State's offers time served, Judge.
Okay.
Judge, my understanding is speaking Mr. Gibson, as far as the state offense, he wishes to resolve that count. I don't know if the court wishes to inquire in reference to count 2.
All right, Mr. Gibson, count 1 is the state charges the possession of drug paraphernalia, and the state's offering adjudication and time served to resolve that case. The municipal ordinance matter, there's not an attorney from the city, but the charge is unlawful assemblies. So my question to you is, we can resolve the drug paraphernalia, but then the other one will be outstanding. Do you wish to wait for an attorney to resolve that, or do you want to resolve that, the second count as well today?
I'd like to resolve the second count as well.
Okay, so then what I will do, sir, is I will offer you a withholding court costs on that second count. Do you wish to accept that?
Yes.
All right. Then please raise your right hand, Mr. Gibson.
All right.
Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Do you understand everything that's going on today?
Yes, I just didn't understand thoroughly about the unlawful assembly. Like, that didn't make, I was like, they really just caught me off guard. I didn't really understand it too well.
Well, that's the matter that you were supposed to go to court on November 13th of last year.
Oh, okay, now it makes sense to me now. Okay.
So it's a KPS from last year.
All right. That's a failure to show in court.
Right, on
Right,
that
okay.
charge. Okay. All right, so do you understand everything that's going on today?
Yes.
Do you need more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case today?
No.
All right. Have you ever been under the treatment for mental or emotional illness?
No.
Do you understand that by taking a plea today, you're giving up your right to go to trial?
Yes, I do.
Do you understand that if you're not a U.S. citizen, taking a plea could subject you to deportation?
Yes.
All right. Then, Mr. Gibson, as to counts 1 and 2, what plea do you enter?
No contest.
All right. Then the court accepts your no contest plea. As to count 1, sentence you to adjudication and time served, and count 2 will do withholding court costs. Good luck, sir. I'm sorry. Yes. 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 Thank you. Mr. McLawrence, what do you have?
Judge, I have Gregory Laster. He's on page 5 of the docket. He's in the main jail.
I don't. Laster?
Yes.
Okay.
He's about 9 persons down from.
I got it.
Okay.
Good afternoon, Mr. Laster. Sir, you're before the court.
Press that button on the speaker in the middle button.
You're before the court on a misdemeanor capias. It's a municipal ordinance matter. And on count 2, there's a out of state hold out of Alabama. There's you should be going before the extradition court as to that count. The court does find probable cause as to the municipal ordinance. Mr. McLawrence, what does your client wish to do?
Judge, he wants to resolve the municipal ordinance so he can focus on this matter out of Alabama and figure out what's going on and take care of that whenever he can.
Okay. The municipal ordinance is an alcoholic beverage violation. The court will offer a withhold adjudication and court costs. As to that count.
Did you hear that, Mr. Laster?
Yeah, I heard it. I'm willing to resolve today.
Okay, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Please state your name for the record.
Gregory L. Laster.
Mr. Laster, do you understand what's going on here today?
Yes, ma'am.
You can put your hand down, sir. Sir, is anyone forcing you to resolve your case today?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Have you ever been treated for emotional or mental illness?
Yes, ma'am.
Are you taking any medications today that would affect your decision?
No, ma'am.
Okay. Do you understand that if you're not a U.S. citizen, that you could face deportation hearings?
Yes, ma'am.
Mr. Gibson, Mr. Laster, I'm sorry. As to count 1, what plea do you wish to enter at this time?
No contest.
Then I accept your no contest plea. I find that it's freely and voluntarily given, and I sentence you to withhold adjudication and court costs. Good luck, sir.
Good luck to you, Mr. Laster. Remember what I told you. The less you say, the better it's going to be for you. So please keep your mouth shut.
I got you.
All right.
Appreciate it.
Jorge Valdez.
He's here present, Judge at Maine.
Mr. Valdez, good afternoon.
Good afternoon.
Sir, you're before the court for misuse of 911 system. The court does find probable cause. What does Mr. Valdez wish to do?
Judge, my understanding is Mr. Valdez is a registered voter here in Broward County. He does work. Normally this wouldn't be a problem posting a $100 bond, but unfortunately when he was arrested, he wasn't allowed to take his phone or his wallet with him, so he has no funds to post his own bond, nor does he have any phone numbers memorized in order to call anyone to post his bond. Right now he's kind of in a bind, so we're going to ask the court to consider releasing him ROR on this offense.
Okay, RR, Mr. Valdez, good luck, sir. No more calls to 911 unless it's for real. Justin Thompson,
Mr. Thompson is approaching, Judge.
Mr. Thompson, you're before the court this afternoon for DUI, alcohol or drugs first offense, and then there's a traffic violation for disobeying a red light. The court does find probable cause.
Judge, at this time, nothing to add. His parents are going to be posting his bond.
Okay, your bond is $500 as to the DUI. Good luck. Luis Hubie,
He bonded.
Derek Sanders.
Mr. Saunders is here present, Judge. He informed me as private counsel, Mr. Stephen Melnick.
Yes, Judge, I spoke with Mr. Steve Melnick. He's going to arrange for Mr. Sanders to be bonded out of jail, so I'd ask the court to leave the bond where it is.
Mr. Sanders, the court finds probable cause. There has been communication with your private attorney. Your bond is $25. Good luck, sir.
Okay, ma'am, may I ask you a question?
As long as it's not about your case.
Okay, then, I'm not gonna waste your time.
Okay.
When did you guys speak to him, if you guys don't mind me asking?
A couple minutes ago.
Uh,
Gregory Nelson.
He's here present, Judge, at Maine.
Good afternoon, Mr. Nelson. Sir, you're before the court this afternoon for a traffic KPS. The driving while license suspended was the charge. The court does find probable cause. What does Mr. Nelson wish to do?
Judge, in speaking with Mr. Nelson, he wishes to resolve the matter today.
Does the state have an offer for Mr. Nelson?
Withhold court cost, Judge.
Okay. Mr. Nelson, the state's offering a withhold adjudication and court costs to resolve your case. Do you wish to resolve your case with that offer?
Yes, I do.
This is a driving while license suspended matter. I don't know what your driving record looks like, so do you have enough time? Have you had enough time to speak with your attorney to talk about those possibilities and repercussions?
Yes, but basically it was a situation in which I had.
Wait, hold on.
Go ahead, sorry.
All right. It was withholding court costs was the offer, right? All right. So, Mr. Nelson, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down, sir. Please state your name for the record.
Gregory Nelson.
And Mr. Nelson, do you understand what's going on here today?
Yes, I do.
Do you need any more time to speak with your attorney?
I don't.
Are you under the influence of any alcohol or drugs?
No, I'm not.
Have you ever been treated for emotional or mental illness?
No, I haven't.
Do you understand that you have the right to go to trial and that by taking a plea this afternoon, you're giving up that right?
Correct.
Do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation?
I understand.
Okay. All right. Then what plea do you enter, Mr. Nelson?
No contest.
Mr. Nelson, I accept your no contest plea. I find that it's freely and voluntarily given. The court sentences you to a withhold adjudication and court costs. I'll give you 6 months to pay your court costs. Good luck, sir.
Thank you. Thank you.
Andre Clements.
Mr. Clements is approaching, Judge. He's here at Maine.
Mr. Clements, you're before the court today.
Judge, we're going to be waiving formal reading of the charges.
Are these ad charges?
So who's this?
Clements.
This was the one we brought him back for the VOP and also to advise him no victim contact.
So we did handle count one.
Bond was posted this morning, but you wanted to issue no contact with AB. B.
AB.
Yeah.
All right, Mr. Clemens, was he in court? Is that what happened?
No, he posted his bond, Your Honor, but I advise you he was still in custody, and then we found out that he was charged with the 94806. Your Honor, the only other thing I would ask is order of no contact with minors and abundance of caution.
Okay. Mr. Clemens, the court does find probable cause, and I believe that your bond was already posted on the first count. On the violation of probation, my notes indicate that you go to court tomorrow at 8:30. And the last thing that I wish to let you know is that you should have no contact with the victim AB in this case, nor any contact with any minors. Okay? Good luck, sir.
Okay.
Kevon D'Angelo McBride.
He's approaching, Judge.
Mr. McBride, good afternoon. You're before the court today for count 1, possession of burglary tools with intent to use. 2, burglary of an occupied conveyance unarmed. 3, contributing to the delinquency or dependency of a child. And 4, resisting officer without violence. The court does find probable cause. Does the state wish to be heard as to bond?
Just, I wanted to advise the court, Mr. McBride has a pending case in drug court before Judge Porth for possession of alprazolam. I do see June of last year, no bond capias was issued for a failure to appear. He was then ROR'd at a later date.
Okay. Mr. Romero?
Yes, Judge. Mr. McBride is 19 years old. He is a senior at Sunrise High School. He lives in Fort Lauderdale with his mother. Unfortunately, his mother's right now not working. So he's going to be contacting his girlfriend to help post his monetary bond. His girlfriend basically does hair on the side, just from what he advised me. He believes that maybe she can come up with if the bond were $2,000 using the services of bond. And so I'm going to be requesting the bond to be left on count 1 as $1,000, the bond on count 2 to be $1,000, and I'm going to be asking the court to consider an ROR on counts 3 and 4. So the total bond that we're going to be requesting is a $2,000 bond on his behalf.
All right. The court does find probable cause as to count 1. I'll impose a bond of $1,000. Count 2, $1,000. Counts 3 and 4, I'll ROR Mr. McBride. Good luck, sir. Carlton Terrell Quince.
Mr. Quince is here present, Judge.
Mr. Quince, good afternoon.
How you doing?
I'm well. Sir, you're before the court for failure to comply with registration. The court does find probable cause. I'm going to impose a bond of $500. Good luck, Mr. Quince. Devontre Ward.
Mr. Ward, I've been advised he bonded, Judge.
Michael Gelante.
North Broward.
Your Honor. That's Galanti, Your Honor.
Thank you. Good afternoon, Mr. Gelante.
How are you?
I'm well. You are before the court this afternoon for 1 count of possession of cannabis, 20 grams or less, possession of methamphetamine, and possession of drug paraphernalia, and 4 is a traffic infraction, disobeying the traffic device. The court does find probable cause.
Your Honor, I'm going to consider asking you to release Mr. Giuliante on his own recognizance on this case. He is a lifelong resident of Florida, and it appears as though this is a residue case, which may ultimately be filed by the state attorney's office as a possession of drug paraphernalia rather than as a felony. Unfortunately, right now, he has a disability, unable to save up any money because of that disability, and is unable to afford the monetary bond as it stands at $1,000.
Your Honor, I don't know that it's a total residue case, and it appears there was substance still in the syringe. Not necessarily a large amount, but I would be asking for pretrial. He does have a possession of heroin from 2013, uttering a forged instrument from 06.
Thank you. I do find probable cause. I would, in lieu of the bond, release him to standard pretrial release with random testing.
Michael, what would you prefer? The judge will release you without the necessity of posting a bond, but you'd see subject to random testing. You'd have to check in with pretrial release. Would you like to do that?
I would love to do that.
Okay, make sure you check for your court dates. Don't miss court, okay?
Absolutely not.
Here's your paper where you got to report.
Good luck, sir. Sir?
Thank you.
Sir.
All right, you're good.
Thank you.
And yeah, and pretrial release. Charles Harris. Where's Mr. Harris? There's somebody walking forward, I don't know. No? Charles Harris.
Mr. Harris? How you doing, Jan?
I am well, Mr. Harris. Good afternoon. Mr. Harris, you're before the court this afternoon for 1 count of possession of cocaine, 2, resisting officer without violence, then counts 3 through 11, 3 through 11 are violation of probation matters. The court will leave the bond in place for count 1 at $1,000. I won't impose another bond on 2, and then the remaining counts, you're on no bond violation of probation holds. My notes indicate that you should be going to court tomorrow at 8:30. So good luck, sir. Friendly Jean Baptiste.
Oh, he has private accounts? Judge, Mr. Jean Baptiste advises he has private accounts. No, go ahead.
Was this a gentleman that was here
That's
this
what
morning?
she's talking about.
No, Your Honor, that was Mr.
John
Vail.
who?
Judge, he changed his mind. He's going to apply with the public defenders.
Okay, Mr. Jean Baptiste, you're before the court this afternoon for 1 count of careless driving, which is not for magistrate, 2, resisting officer without violence, 3, 4, and 5 are misdemeanor capias, 5 and 6 are felony violation of probation. So I find probable cause, and the bonds that are in place will remain, and my notes indicate that for your felony VOP matters, you should be in court tomorrow at 8:30, and on the misdemeanor matters, you're scheduled for February 1st. Good luck, sir.
Judge, can you sign a photo order, please?
I will.
Thank you.
Charles Thorpe. Mr. Thorpe, was he the one for the
Mr.
private
Thorpe is
attorney?
approaching,
No,
Judge.
it looks like you got charged with an out-of-county hold on count 3. You handled 1 and 2 this morning.
Well, I have the paperwork. I have 1 and 2 again.
Yeah, I don't know.
Count 1, you had given him a $2,000 bond.
Okay,
No victim contact, no use of social media site.
okay. Was this a gentleman we needed to give the order of no contact?
No, that was, we had him earlier.
Oh, okay. So why is Mr. Thorpe back?
Literally, it should just be count 3, the out-of-county hold. I don't know, I know.
I don't even have that. Yes, he was in court this morning.
Okay. Then he probably shouldn't have been brought back.
Okay. All right, Mr. Thorpe, I know you were before the court this morning. What we did this morning stands. I believe that there is some out-of-county hold. I'm not sure. I don't have that before me today, so I'm not gonna make any changes from what we did this morning. Okay? Take care. You didn't sign? Oh, well, maybe that's what, I don't. There was not another one this morning? Okay. Okay, oh, I have these 2 from this morning. All right. Then we have Gentina Littles. That was from this morning, a reset from this morning.
Yes, reset from yesterday and then reset from this morning.
Oh.
Your Honor, do you still have the paperwork I provided yesterday? If you don't, that's fine, I have.
I don't.
Okay.
Thank you.
Your Honor, this is a technical change of charge. When he was first arrested, it was booked as murder. The state filed the charge as attempted murder. I don't know necessarily what happened or what was discussed or argued at his first appearance. All I know is Judge Murphy, who had access to the probable cause affidavit I've attached, set his bond at $50,000. Your Honor, I am going to be seeking a no bond hold upon the finding of proof evident or presumption great, and I'm making that for first appearance purposes only. And I'm making that argument. I provided the court and I provided defense counsel yesterday with the supplemental report, which has additional evidence and information that was not presented to Judge Murphy at the time of the original first appearance. Included in the supplemental report, it mentions a second witness, in addition to the victim and the witness that identified Mr. Littles as the shooter. Additionally, it mentions, Your Honor, that, one moment. The firearm was also located that was used in this. It was hidden under a fridge, which I believe where Mr. Littles was, and I believe that does that implicates Mr. Littles with additional evidence. I would also note the firearms, the shell casings that were found at the scene of the shooting matched the ammunition that was found in the gun that was recovered under the fridge, under the refrigerator that was hidden where Mr. Littles was found. Lastly, I would also note, Your Honor, the statements that Mr. Littles gave were contradicted by the evidence. Mr. Littles claimed that he was being robbed by someone, not the victim, just that he was being robbed, but he didn't shoot anyone. And that's why, but as you can see, there are 3 witnesses all saying that Mr. Littles shot the victim. Additionally, he changed his story upon when he was questioned by law enforcement. First stating that he was staying in the area where the gun was found, then stating he's homeless, he doesn't have a residence local. Then when law enforcement spoke to neighbors, they were advised, yes, he does in fact stay at that apartment where the gun was found, and he has a mailing address there in the area as well. Your Honor, I believe, based on the additional evidence that Judge Murphy did not have access to at his first appearance, that the court can make a finding of proof evident or presumption great at this time.
We would ask the court to keep Judge Murphy's original rulings in place. The judge was aware that there were witnesses connecting Mr. Littles to this offense, and the information additionally provided by the state does not justify proof evident presumption great, certainly not to the extent that Mr. Littles should be held without bond at this time. Proof evident presumption great is the highest standard of proof that we have in the criminal justice system. Judge Murphy's review of this case, he felt that that was not an appropriate resolution. I don't know if he found proof, evident, presumption great and exercised his discretion to set bond, but either way, I would ask the court to do that and to leave Mr. Little's bond at $50,000 at this time.
Mr. Linder, the supplemental report, is that what you're saying that was not available at the first hearing?
It was not.
And do you know if there was a determination of proof evident or presumption great?
The problem is I don't know, Your Honor, because, and I'll check again, but I believe it was not documented either way on the original findings. I'm pulling that right now. No, Your Honor, it doesn't, no, it doesn't, it says probable cause was checked off. It doesn't mention if Judge Murphy made a finding of proof evident or presumption great and decided to set a bond anyways, or if he didn't make that determination.
Okay, just give me a moment, let me read the supplemental. All right, thank you. Mr. Littles, you're before the court this afternoon for, there's a felony capias, and there is attempted murder in the first degree. The court does find probable cause. Mr. Romero, do you wish to speak?
Judge, my understanding is, as Mr. Little's been in custody since December 22nd, on that $50,000 bond. I know he has friends and family in the community, and they're trying to do their best to come up with a bond, but unfortunately they've been short. The good news, Mr. Little's did advise me, he does have work waiting on him. But right now it's just something that his family is doing everything possible to come up with the bond amount. I just want and reiterate my colleague's argument and ask you at this time to set this same monetary bond which Judge Murphy set on December 22nd.
And Your Honor, it's more than just that. If the court is inclined to set bond on both counts, because we also have an add count of possession of firearm by convicted felon, I'm going to be requesting a $50,000 bond on that count, pretrial release with a GPS monitor level 1, noting not just the allegations that he fired at a victim that was running from him multiple times, shot him twice, once in the ankle, another time in the leg, breaking his femur. But I would also know Mr. Little's criminal history. 2015, violation of a domestic violence injunction. 2015, he pled out a felony to a misdemeanor battery. 2009, robbery by sudden snatching. He was convicted, sentenced to 15-month state prison as a habitual offender. 04, burglary of an occupied dwelling and 1 count of battery. He violated probation, sentenced to 25 months in state prison. He does have 2 drug priors from the mid-90s as well that he went to state prison on.
Judge, in reference to the bond amount, count 2, as far as the possession of a firearm, $50,000. I mean, unfortunately, if he can't make the $50,000, which was currently played, he's not going to be able to make double that, $100,000. Judge, I'm going to be asking on that particular charge to consider a $5,000 bond, along with count 1, $50,000 would be $55,000. I do understand the state's concern. We wouldn't be under pre-trial release. He would be going to reside with his sister who lives in Fort Lauderdale. His sister's the one that's coming up with, hoping to come up with the bond amount, but she works at Winn-Dixie. I know from what he told me, she's been working hard, but he owns no sort of property, has no sort of money in the bank. That's just his financial resource. He has none.
Okay. So the felony cases is the possession of the firearm. That's on my PC. That's that charge, the possession of firearm by a convicted felon?
Yes.
Okay.
Yeah, I see what you're referring to. Yes, Your Honor, that's correct.
Okay. All right. I have reviewed the probable cause. I've reviewed the supplemental report that was provided to me today that I have read. I do find that proof to be evident. I am going to hold Mr. Little's as to count 2 on no bond until further order of the court. Mr. Little's, understand that this is not the end of it. You can have an author hearing before your division judge, and your attorney will be able to advise you in regards to that. On count 2, the bond, I'll impose the bond of the $50,000. I'm sorry, 50. I'm writing it in. Okay, then Eric Vale. We have Mr. Vale. Counselor, are you here?
He's here, President Judge.
Mr. Vale, good afternoon.
Good afternoon.
Sir, you're before the court this afternoon for premeditated murder, 1 count. The court does find probable cause. What do the parties have to say?
Judge, over the lunch hour, I spoke again with Mr. Evan Crawford.
Oh, that's right.
He indicated to me that the family met with Mr. Michael Robinson, who's going to be the attorney of record. They are going to hire him, but they're not going to be able to come up with the money until the end of the week. So he will not have counsel in that regard until the end of this week.
Okay. So for these purposes, today, Mr. Vale, are you using the services of the public defender's office?
Yes, ma'am.
Okay.
Yes, ma'am.
Mr. Linder?
Thank you, Your Honor. On this charge, murder in the first degree, I'm going to be requesting a no bond hold upon a finding of proof evident or presumption great. For first appearance purposes, relying upon the arrest warrant affidavit prepared by Detective Samantha Cottom of the Broward County Sheriff's Office. I have provided defense counsel with a copy of the affidavit, and Your Honor, I provided you with a page to that needed to be included in the affidavit to complete it. Just noting, Your Honor, both the physical evidence from the offense, and also, Your Honor, I would note Mr. Admissions or statements made by Mr. Vale, which completely contradict are contradicted by the evidence, Your Honor.
So the state, oh, sorry.
All right, Mr. Vale, you're charged with murder in the first degree. The court does find probable cause. I've reviewed the probable cause affidavit filed in your case. There's all 12 pages. I reviewed them this morning and this afternoon. So I also find proof of guilt to be evident, and so therefore I'm holding you no bond. This order is without prejudice to you. You can file a motion to set a bond with your assigned division judge and or request a hearing, author hearing. Good luck, sir.
Judge, before we adjourn Mr. Vale's hearing, we would be invoking his Fifth Amendment right to remain silent. We would be putting law enforcement, I believe there's law enforcement on this case present in the courtroom, as well as the state attorney's office on notice that they are to make no attempt to contact Mr. Vale without first contacting his attorney, whether it's the Office of the Public Defender or private counsel, as we anticipate will be retained. And Mr. Vale, I'm advising you, sir, do not discuss this case with anyone except your attorney. Do not talk about it on the phone. All your conversations are being recorded, and they are listening. So do not discuss the case with anyone in the jail, with anyone on the phone, with anyone but your lawyer. Do you understand, sir?
Yes, sir.
Okay.
And no contact with the alleged victims in this case, or the victims in this case. All right. Counselor, what case are you here on?
Hi, Judge.
Good afternoon.
Philip Mendito, I apologize. I didn't have court today. I just got called, so I would have had a suit on. So
I'm gonna put you out the door, sir.
Judge, I have Justin Thompson. I was alerted that he'd be in this afternoon, but apparently he was called this morning.
Oh, because
He was this afternoon.
Oh, he was?
Yeah.
Okay.
Your Honor, was advised his parents are going to be bonding him out. It was a DUI with a $500 bond.
Okay.
Okay.
All right.
Terrific.
Thank you.
Thank you, Judge.
No problem.
Have a great day. Nice to meet you.
Same here. You too.
Thank you. I need to keep one in the office now. Have a great day, guys.
Matthew, we'll go to the felony docket. It's Matthew Blackney.
North Broward, Your Honor.
Here, Your Honor.
Mr. Blackney.
Yes, ma'am.
Mr. Blackney, you're before the court today for a motion for ROR. You were arrested on December 29th. What's the story with Mr. Blackney?
No, Mr. D. Casanova was arrested on the 29th.
Oh.
Mr. Blackney was arrested on the 18th.
Oh, okay.
He's Mr. Blackney.
Mr. Blackney, I'm sorry. I was giving a different arrest date. Your arrest date is January 18th.
He's here for a second look.
And so you're actually here for a second look.
Mr. Judge, I'm going to ask you to consider putting Mr. Blakeney on ROR status. He does have a place to stay, and he does have a job. He works as a painter. In reviewing the probable cause affidavit in this case, although I guess it is resisting arrest with violence, it could even be filed as a resisting arrest without violence. None of the officers were actually struck or hit by Mr. Blakeney during the course of this incident. He laid down on the ground and flailed his arms and legs, but there's no indication in the report that anyone was actually struck by those activities. So no officers were injured. He has been a resident of South Florida for some time, and he cannot afford to make a $2,500 bond. The job painting that I referred to earlier is a job that he just started, and he has not yet received any payment from that job, so he does not have the wherewithal to come up with any type of monetary bond at this point.
And, Your Honor, if we're going to talk about the facts, the explanation that Mr. Reedy gave is the very reason why he was charged with resisting with violence. If he actually struck an officer, he would have been charged with battery on a law enforcement officer. So I don't know that legally speaking, makes a difference with regards to this charge of resisting an officer with violence. I would note, reading the PC, it's really a little bit more than Mr. Reedy described, considering when they first brought Mr. Blackney into the vehicle, the police vehicle, he almost shattered one of the windows, kicking the door in the window, and it goes on from there. I would also note, while not necessarily very, a significant offense, he was, when he was arrested, out already on a possession of cannabis. Looks like his release was revoked in that matter, and he has since his arrest resolved that case. And I guess, Your Honor, what I'm saying ultimately is, if the court is inclined to modify the bond, I would ask that he not be given an outright ROR. I don't know that would be appropriate, considering his history, which includes 2014 possession of methamphetamine and false name ID, 3-year state prison. 2014 introduction of contraband, methamphetamine, possession of methamphetamine, 3-year state prison. Theft 2012, 2011, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. He was convicted of 11 separate burglaries of conveyances. On all those cases, he was sentenced to 5 years in state prison after violating probation. And in 2006, he had 2 separate robberies with weapons and falsely impersonating a police officer during the commission of a felony.
And the bottom line still remains, Judge, Mr. Blakeney cannot afford to post any type of monetary bond. So, I mean, if the court felt pretrial release, standard pretrial as a condition of release on his own recognizance is appropriate, I think Mr. Blakeney would be agreeable to that.
I would be willing to place Mr. Blakeney on standard pretrial release supervision, also adding random testing.
That's fine, Judge.
Okay.
Thank you, Your Honor.
Good luck, Matthew. Sir. Don't miss court.
Yes, sir. Thank you again.
You're welcome, sir. So then let's go to Raul D. Casanova.
Good morning, Mr. President. Main Judge.
Okay. Mr. D. Casanova, good afternoon.
Good afternoon to you.
Sir, you're here, I guess yours is a 30-day motion for RR. You were arrested on December 29th. Today's the January 29th. We're on the 30th day. What says the state?
Your Honor, we have not filed information at this time. He is entitled to an ROR on these charges.
Okay, so then I'll grant the ROR, Mr. D. Casanova. You need to still know that you've got to watch your mail to see if you receive any notice for court. This doesn't mean that the case is over or dismissed.
Yes, ma'am. He was just explaining that to me.
Okay. Good luck, sir. On the misdemeanor docket, Siltane DeBruce?
I'm advised by North Broward that they're not going to bring her, Judge. She is scheduled for a hearing before Judge Lerner Wren tomorrow morning.
Okay. And his was just okay. His was a second look. So he's going before Judge Lerner Wren. All right? Am I missing something? What's the page what? Which one? Nathan Nguyen? He was released. Yeah. Yes, that's.
Answer. And that's again.
All right, then I think we've come to the end of our docket.